rise. Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in the matter of State of Arizona versus James Rocco, our criminal number 18-0697. Each side will have 20 minutes within which to present their argument here this morning. The appellant may reserve some portion of that for rebuttal. You have to keep track of your time in that regard. We have read the briefs, we've been through the record, we've conferenced the case. So we're familiar with the underlying facts and the issues as identified in the briefs and in the supplemental order that went to council some days ago. With that, the appellant may proceed.
Good morning. I'm Lisa Marie Martin, representing the state of Arizona. I just wanted to start out quickly and address the issue that the court raised in its order in terms of, did the defendant have to go through Rule 32, or I guess now it's Rule 32 and 33, or in order to raise the issue of striking the GPS, and did the court have jurisdiction, the trial court, considering that the defendant had not gone through Rule 32. First of all, the state believes that the defendant could have gone through Rule 32, and if the defendant had gone through Rule 32 and said GPS should have been stricken, the state could have argued, well, no, you didn't appeal from your original plea agreement 90 days after your sentencing from your original plea, which had GPS in it, and therefore the issue should be precluded. But in fact, I did not answer. I did file something with the court stating that I did believe that the trial court had jurisdiction because of a case which I myself lost in this court, which is State versus Dean, which was also a sentencing issue based on the Peak case, where there were certain defendants that were on lifetime probation, and it was found to be for a certain period of time was not authorized by the statute and by the applicable statute. And the probation office, because I guess they didn't want to monitor for a lifetime if they didn't have to, all these people, they actually brought it to Judge Granville to say, could you modify this? And he was modifying a whole bunch of different cases. And I actually did an appeal, and one of the issues I raised on appeal was, no, this has to be brought in Rule 32. And actually this court said, well, we don't know, we're not even going to decide if we have appellate jurisdiction. We're going to take this as a special action. And said, first of all, this wasn't the defendant that brought this to the trial court, it was the probation office. But then the second part of the holding was that the trial court, when a defendant is on probation and being supervised, that they always have jurisdiction to address the terms or modify the terms, even if the Rule 32 had not been brought.
But setting aside, first we have the distinction, this isn't a probation officer, so we don't have the Rule 27 exception that Dean really focused on. Then for the second part, we don't have a change in the law that was present in Dean to support this change in the terms, do we?
Well, from the defense point of view, I think they would argue that we have a statute that was passed after the defendant had committed his crimes that provided for GPS.
But what we don't have is a Supreme Court case saying it's an ex post facto issue that they would have to rely on the same way they could have relied on people, correct?
That's correct. But in terms of the court having jurisdiction, I felt that State versus Dean would say that the court would have jurisdiction to address a probation term. Now, even if it's incorrect what the court did, I felt that the court had jurisdiction.
And does the court, though, have jurisdiction to modify the plea agreement? outside of the Rule 32 petition, because this was a term not just imposed by the court as a condition of the statute, but as a condition of the plea agreement itself, wasn't it?
It was imposed when the plea agreement described basically the consequences of these particular offenses that he pled to. The first part, when it described the range of the sentence, and then after that, it cited that mandatory GPS monitoring was required.
And it didn't cite any particular statute. It just said mandatory GPS is going to be a part of this, and violation of that is a class 4 felony.
I believe that the actual plea agreement did not cite a statute. I would have to look at that, but I know that there's been an argument that the sentencing minute entry and a lot of the subsequent dispositions mistakenly kept referring to the statute that is interfering with a GPS equipment, and that statute came into effect at the same time that the mandatory GPS came into effect, and I think it was just basically a clerical error that kept being repeated, because it really should have said 13902G. But yes, the plea agreement, it wasn't part of the paragraph 2 part where the parties are agreeing to this. It was part of the first part that said this is imposed. So in terms of whether...
And so the class 4 that was cited in the plea agreement was 133725, so it wasn't the problematic.
Correct. And that's something I think that it wasn't really brought up so much on appeal, but it was an argument that the trial defense attorney made, that everything was wrong because that wrong statute was put in. And it's clear that that was a clerical error. And speaking of errors, I said that this court could fix it under, I think I said Rule 31.17, and that rule actually is for something else now. It's not to fix mistakes, but there's still the statute 134036, which is a little more formalistic, but I think says the same thing. And if that is seen as some kind of impediment, that statute can be fixed as a clerical error. Getting back to whether a court could have the jurisdiction to modify a plea agreement, I think if the court found that there was some illegal sentence, that the state should have known about, we see that but we do see it in post-conviction relief motions, not in striking terms. But I do feel that, like Dean, even though there are some differences, that the court, again, I don't in any way, that's why I'm appealing, I agree with what the court did, but in terms of did the court have jurisdiction to address a condition of probation as a judge that's supervising a probation, I think in terms of jurisdiction, I candidly think it does. I wish.
Say we agree they can modify terms and conditions of probation. Can they modify the terms of the plea? That's a different situation, isn't it?
I think a court could modify it if something was found to be improper or illegal in a plea. But in terms of modifying a plea agreement just for probationary terms, I think the court had the jurisdiction to at least say, I can address this term. I don't feel, and I think I brought up that I didn't feel that she should be able to modify the plea because that was in his plea.
Okay, and here the trial court didn't even specifically find the term was an ex post facto. The court didn't say that any of those were true. So we don't even have the trial court, let alone the Supreme Court decision.
That's correct. It's kind of hard to figure out what the trial court actually did, and I frankly think that she really didn't do anything. She did start out, having a discussion with the parties and listening to the argument, but then at the end of Commissioner Brickner's discussion, she basically said, I don't even know why we had oral argument because the state didn't file a response, and since the state didn't file a response, she's basically going to grant it because the state didn't file a response. and I think that's why she granted it. But then, when she did grant the motion to strike based on the motion to strike the GPS, based on the fact that she had stricken the state's pleading, she then went
Why don't
on.
we talk about that a second? Because
Okay.
where's the abuse of discretion?
I think there is an abuse of discretion because, I know that I've been faulted for saying basically two wrongs should make a right. But when a court exercises its discretion, the court has to consider everything. I know the court didn't know why the pleading was late, because unfortunately the attorney that filed the pleadings 2 days late wasn't there, and a coverage attorney was sent. And perhaps, I think it would have been better if I was covering and someone wanted to get into something that I didn't really have specific instructions for. I would have asked for a continuance till the attorney could have done it. But nevertheless, he did ask, can you please consider this in the interest of justice? So it seemed like the court was basically just striking the GPS because the state had not filed a pleading, and so she was just going to give the relief that the defense had asked for. But then she went on to say that, since the violation was based on a failure to charge his GPS, that can't stand anymore either. Because that term now isn't even here. So I have to also, not only are we not having a disposition today, I'm going to vacate the violation that I found a few weeks ago, and I'm going to I think she even vacated the petition to revoke. So it was as if everything just went, unwound and went backwards. So for her...
So if she had the discretion to strike that, grant the motion, are you saying what she didn't have was under that, it was an abuse of discretion to go back and strike the petition to revoke in the first place and the underlying violation because it was a condition at the time?
Yes, and also I was kind of trying to answer your question as to what did she do? Did she decide it based on ex post facto? And although we can't really tell, the fact that she went beyond just striking the term to go back and say, well, GPS shouldn't have even been a term, to me kind of said that she was saying it was improper. It was improper to be a term, which you can infer is accepting the ex post facto argument.
Okay, so let me interrupt just so that I can
Yes.
follow. So is it your position that the court did have the authority to go back and modify a term of the plea agreement?
I do not. I do not think that she had, and I that's why I did put that in the factual part of my brief, and the defense was even trying to get the change of plea hearing, which unfortunately has been destroyed. But I was just relying on the plea agreement itself, saying if this is in there. I think that she had the jurisdiction to address a term of probation. As far as actually modifying the plea agreement, I think she exceeded, any authority that she had. But in terms of actually having jurisdiction, I see that as, I love to say that she didn't have jurisdiction. I just frankly feel that she did have jurisdiction. I think she exceeded, abused her discretion and exceeded her authority.
So your position is that when the stipulation of the state and a defendant in a plea agreement involves a term of probation, then the court can always go back to the original plea agreement and modify it?
Well, I think what happened in Dean is that I believe that there were many plea agreements that said that a certain sentence applied, and then, as Scott said, the Supreme Court then said, no, if for these particular years the statute didn't support that. So I think, in a sense, they did go back and modify by taking out and reducing all those people's lifetime probation to 5 years.
Right, but there's a difference between an agreement that rests upon the ill-conceived notion that it is required, that the lifetime GPS monitoring is required per statute, and then we get clarification that tells us that's not the case. Then we have to look at those sentences again. But isn't that different from a situation where the parties get together and say, regardless of whether it is mandatory, whether it's required or not, we will agree that you, Mr. Defendant, will be on probation, will be on GPS monitoring for the rest of your life, right?
I think those would be different, but I don't think that's what this plea did, because it wasn't in paragraph 2, which is where the state and the defendant are agreeing to particular terms. It was in the part that describes this is what's applicable to these crimes. Do you see what I'm saying?
I do.
And
So it was in your position, as much as you'd like it not to be the situation,
Correct.
is that that even though it was not clearly stated, the state's stipulation to lifetime GPS monitoring rested on its understanding, or the party's understanding, of what the law required at the time.
correct. And it, just also to continue on, was the court deciding it on ex post facto grounds? I think what confuses it a little bit more is Commissioner Brickner's decision on the motion for reconsideration, is because then on the motion for reconsideration, she says at the end of it, she's denying the motion for reconsideration, and she says something a little bit bewildering, like, but this only applies to this defendant. But then she says, but in the future, if someone comes to me and says that he should get GPS monitoring, I will have the discretion to impose it. And if you look at the defense argument, that section that gave the court even the discretion to impose GPS monitoring, that didn't come in until 2009. So the defense argued that would be barred by ex post facto, yet the court said, but I do have that discretion. So then it's puzzling to me what basis she really did decide it on. Whatever basis she decided it on, I believe it was an abuse of discretion. I believe it was an abuse of discretion for her to reject, to just throw out and strike a pleading that was 2 days late. I understand that judges have an ability to control their docket, but this was a quite serious case. And she had read the state's response, which showed that there were, constitutional issues of public safety, issues even of the defendant's safety.
But shouldn't the state have done a better job of telling the court why the tardiness in filing was justified, or more than just this is how we do things, nobody takes the violation of probation hearing seriously? I mean, shouldn't the state's representative have given something?
Well, at the time when the pleading was stricken, like I said, there was a coverage attorney, and sometimes, frankly, that's just not perfect. I mean, I've been in the position of being a coverage attorney and not having correct instructions or not, and so a lot of times I'll just, if I were that attorney, I would have asked for a continuance when I saw what was happening, and hopefully would have gotten one so that the attorney who had done the pleading 2 days late could come in and explain. And she only worked half days, so there's a whole bunch of confusion. When she did do her motion for reconsideration, I disagree that the only reason she gave was, deadline. She did say something to the effect, deadlines usually aren't so strictly enforced in probation matters. But that it sounds really callous or and dismissive to say that. But really, what she was trying to explain that there was a lot of agreement, especially because not only was a probation calendar involved, but also the calendar in terms of mental illness, and there were certain agreements as to trying to get him, if he's reinstated, the state would agree to reinstatement. It was continued 5 times, the disposition, because they were trying to get him into a certain position, and even when the defense, I think in response to the motion for reconsideration, attached the emails between the attorneys, and when she filed the motion to strike GPS, the defense attorney said something to the effect, and I have no objection for the state to have time to respond. I mean, to me, that's like, well, of course, because the state gets their time to respond. And it was almost like implicit in there, even though she didn't say it, is I have no objection if the state needs a little extra time. Because she didn't really have any basis to object if the state needs time to respond, because that's like afforded by the rules. And also they had been talking very close to the date that it was due, still in terms of, have you found placement for this person? But again, yeah, there was something lost in the instructions to the coverage attorney. The coverage attorney, and ideally, should have maybe done something different. But when the attorney that was responsible did file the motion for reconsideration, that wasn't the only reason she gave, saying she was trying to say in her experience, things are a little bit more fluid. I don't think she was saying I can file things any time I want. And she did give several reasons. I mean, she didn't lie and say, "Oh, I was deathly ill." She didn't say that, but she said, "Here are all the things we were talking about. This, I thought that there would be extra time, and I wasn't trying to say, oh, well, the fact that the court then let the defense come in with an oral motion to strike." Now, there are all kinds of rules that are violated by that. And I'm not just saying, well, do this for one party, but don't do it to another, to say, like, two wrongs should, make a right. But I am looking at it in terms of an abuse of discretion, because the court has to look at all the situations, the gravity of the issue, the fact that it's only 2 days late. The disposition hearing had been continued 5 times by the defense. And then the defense comes in and tells the court, after that same defense attorney had did the probation violation hearing a couple weeks earlier on GPS, failure to charge GPS, says, "Oh, well, I'm going to do my reply orally, but first I want to strike the state's pleading because it's 2 days late." It was said in front of a coverage attorney, but it hadn't been served on the state. Perhaps if that attorney had known, if the state's attorney had known, she would have made sure she was there, whether it was for her to work or not. So I feel that there were a lot of rules that were just thrown by the wayside in terms of giving, the defense, letting the defense do an oral motion to strike, not having written arguments, not being served, not asking for oral argument and writing on it, and yet the state filed something 2 days late, and there has to be some kind of equity.
Ms. Martin.
Yes. Did I already use up all my time?
You did a little while ago.
Oh, I'm so sorry. Well,
thank you.
I didn't get to any of the issues. No, I'm just kidding. I did.
Good morning. Michael Steinfeld on behalf of Mr. Rocco. I want to go to the questions that were raised by Judges Goss and Cruz regarding the plea agreement, because I think that seems to be the nub of where the court's going with this. And I think the state is actually correct in that what was described in this plea was not necessarily an agreement between the parties. I think Judge Cruz is correct that if the parties had come forward and in paragraph 2 said something along the lines of, regardless of whether it's required by statute, we are agreeing and we are negotiating to supervision via GPS monitoring, something like that would be enforceable. The problem is that did not exist in paragraph 2 in this. The only place where there was any reference to GPS monitoring was in paragraph 1. And I think that that's interesting in a couple of ways. First, what paragraph 1 does is simply define the boundaries of the offense. And so what it does is it creates and advises the defendant of what the law prescribes. It was simply providing an inaccurate description of what the law both provided and required insofar as GPS monitoring was concerned for Mr. Rocco. It was providing Mr. Rocco the state of the law in 2007, not the state of the law in 2005 when he committed his offense. And I think that's important for a second reason that gets to the actual merits, which is its inclusion in paragraph 1 illustrates that this is a term of probation and thus a part of the sentencing, and thus a reason why it shouldn't apply retrospectively in any way whatsoever. Because it's part of the sentencing, our baseline presumption under cases like Newton is that a defendant has to be sentenced under the law that was in effect at the time that he or she committed their offense. Given that that's the baseline presumption, and everyone seems to agree that this was part of the sentencing and thus part of the punishment, there's no reason to apply this retroactively. It has to be applied prospectively. Now, I want to get into the striking of things, because I think that that is the next place that the court kind of went to. Regarding the strike, I don't see this as an abuse of discretion of the court's authority to manage its calendar. Really, the state's sole argument has been that there are some perceived inequities. But the inequities, to the extent that they even exist, are consistent in the court's goal, which was to ensure timeliness and to ensure expeditiousness. Moreover, there's no requirement whatsoever in the rules that both parties get equitable treatment. I'll be honest with you, if I could come in and demand equitable treatment, I feel like I would probably end up doing that a lot.
Can I go back for a second? Because I want to understand your argument. I understand that it was in paragraph 1. But what it said was that it was mandatory lifetime probation, and there was a consequence for life. And isn't what you're trying to do is to strike that out of the plea agreement?
Absolutely.
Isn't that a Rule 32 petition?
No, that's not a Rule 32 petition. That is well, because of what Judge Winthrop wrote in Dean and what this Court of Appeals had decided on several occasions, which is that courts retain jurisdiction over the probation, and they have the authority to strike illegal terms. And I think there's 2 cases that illustrate the court's ability to strike illegal terms. The first is Dean itself, because in Dean, recall that what was at issue in Dean was a lifetime probation term. And what this court ended up doing, outside of a Rule 32 purview or venue, was modify that to a 5-year term of probation.
Based on a petition from the probation officer. Rule 27 played a key role in the outcome of Dean.
I agree, and I would say that Rule 27.3 still plays a key outcome here, because Rule 27.3b subsection 1 says that probation can pursue to modify, but subsection 2, when talking about who may request modification or clarification, says, at any time before the probationer's absolute discharge, a probation officer, the state, or any other person the court designates may ask the court to modify or clarify any condition or regulation. So Mr. Rocco had every right to petition the court to modify the term of probation. The simple fact that it was done by the probation officer in Dean is not the governing factor.
But Dean makes it clear they weren't trying to get into the plea agreement terms. And this is modifying the plea agreement terms.
I would agree this is modifying a plea agreement term, but I would disagree with you in your interpretation of Dean. And the reason I say that is length of probation is a probation term. And if we're changing something from lifetime probation down to probation for 5 years, that's modification of a probation term. But I would also encourage Your Honor to look at the cases that were cited in Dean, specifically dealing with restitution. For example, you have Contreras, decided in 1994, in which the court modified probation in order to add restitution. The defendant challenged that as a modification of the terms of probation, and this court held that the trial court retained jurisdiction. The same thing happened in, I believe it was a case that was cited in Ray. In Ray, the court revoked probation, which essentially is a modification of probation, and argued that that was improper. This court held that the trial court still retained jurisdiction. And in Ray, this court...
That has nothing to do with the plea agreement. I keep coming back to that. The trial court has the ability to revoke probation. That is part and parcel of probation.
No, and I agree with that. What I'm getting to is the citation within Ray, which is to Holguin. Because in Holguin, it was another situation where there was a modification of restitution. Restitution and payment of restitution is a term of probation. And I think what we're missing here is that this isn't an agreed upon term of probation. This is a misinterpretation about what the law required. This isn't something
But we don't have a holding that actually says that there is a mistake in what the law required. Did the trial court say that this is an ex post facto law?
I don't think that they said this is an ex post facto law. They struck, however, the term. And I believe that the most reasonable interpretation of why they struck the term is on the grounds that it applied only prospectively, not retrospectively. That's the most reasonable, I think, analysis of it. But the striking of the term, after there is a motion to strike the term, is a holding that it was improper to apply it.
Is that something we have to decide then? Did the trial court get it right? That this was, in fact, only applied prospectively? How do we say the trial court got the law right without actually dealing with it.
This court does that all the time when the defense tries to argue that a trial court didn't rule something. What I would say is that this court can look at what the trial court ruled, and this court can affirm on any basis that's supported by law. And so the fact that the trial court struck the provision and that there are several mechanisms through which this court can affirm that, that's sufficient in and of itself. This court doesn't need an express holding that this was on ex post facto grounds or that it was on prospectivity versus retrospectivity grounds. It doesn't need that. This court can look at what the arguments were and affirm on any basis that is supported by law.
But I interrupted. You were going on to the abuse of discretion, and I pulled you back.
No, that's fine. If you have further questions, I'm more than
No.
happy to talk about whatever the court wants to talk about. In terms of the abuse of discretion on the striking, the court had the authority to do it. Rule 1.9 says that the court had the authority to do it. And Rule 1.9 does not require the court to exercise its discretion to overlook an untimely filing on any basis. And here, when the motion for reconsideration was filed, there was no discussion whatsoever as to why the pleading was filed untimely. And I think that's key here, because ultimately what the state is talking about in terms of the discussions about why there were expected continuances, why there were housing situations and stuff like that, all of that went to why the attorney did not show up on the day of the hearing. It didn't justify the delay in the pleading being filed in any way. And so I think that we're really kind of mixing wires at that point, or crossing wires at that point, and we're not actually talking about why the pleading was filed in a late manner. We're trying to assign reasons that were given for something else and apply them to the late pleading. Beyond that, the last thing I want to talk about is really, I think, just the analysis of, even if we get to the merits on this, the merits support the trial court's ruling, particularly insofar as it relates to prospective versus retrospective application in this case. And the starting point for that is that the courts are supposed to sentence defendants under the law that was in effect at the time they committed their offense. In 2005, 902G did not exist. And it's a sentencing term. I think that the state has essentially conceded that it's included in paragraph 1. That makes it part of the sentence. When we look at our Supreme Court's decision in Montgomery from 1977, probation is considered sentence. It's considered punishment. And so to impose a punishment that was only enacted after the fact.
Often registration's included in paragraph 1 too, and that's not punishment.
I would agree that registration is not a punishment, and registration is often included in paragraph 1.
And haven't most courts said that the GPS term also is not a punishment?
I would disagree with most. I think that it's closer to an even split. But that being said, there are substantive differences between how ours is placed and how ours operates that's important. And I think that the best way to illustrate this is actually to point to the Wisconsin case that the state cited, which is Muldrow. Because Muldrow had an important discussion in which it distinguished the Michigan Supreme Court's decision in Cole. Now, the difference really boiled down to this. In Cole, it was made part of the punishment in Michigan, and it was defined as punishment. It was included with probation. Whereas in Wisconsin, it was in an off category. It was in a category more akin to where we place our registration assessments. That distinction was important to the court in Muldrow in pulling away from what Cole had ruled. Essentially, it came down to the question of punishment or not. And I think what's most important here is not just placement within the criminal code, but where this is placed within the criminal code. It's placed in 13902. That deals expressly with sentencing. If we look at the actual language, and this is from the 2006 version, beginning November 1, 2006, after conviction of a dangerous crime against children, if a term of probation is imposed, the court shall require GPS monitoring for the duration of the term of probation. Notice that that links this to probation. It is tied in as a mandatory term of probation. This isn't a circumstance like with our registration, where it's more of a status notion that perpetuates and exists outside of probation. This is just a part of probation. It is a mandatory term of probation. I think of it this way. If the legislature had passed a different law that said beginning 2006, after conviction of a DCAC, if a term of probation is imposed, the court shall impose an initial year in jail, that would be problematic because that is changing the time of incarceration. And all they're really doing is still mandating a term of probation at that point. This is a term of probation that operates to a defendant's detriment, makes compliance with probation more difficult, and is more onerous on the defendant. This is a form of punishment. And I think you can see that also from Professor Eisenberg's article, Mass Monitoring, in which she talks about how GPS monitoring fulfills all 4 theoretical goals of punishment. So this being a punishment and this making the terms of probation harsher upon Mr. Rocco and it being enacted after the fact, those all weigh to support the notion that this indeed is something different from how we've categorized our registration act. I think another case that Your Honor could look at, for example, is in Baer, which, is in Bilal, which is the Seventh Circuit case. And in Bilal, what happened there was that the GPS monitoring was tied into a release from civil commitment for high risk of committing a sex offense. Notice that's not even then tied into criminal conduct. It's only tied into a civil finding. That's what Bilal approved of. What we have here is we have a term that is being mandated that makes it harder for defendants. It is placed specifically into 13902G, which deals with probation and probation terms and the length of probation. That it's not placed in 3725 or a similar sort of quasi-regulatory statutory area like our registration scheme. And what we have is a situation also where, because it makes it harsher and because it was enacted after the fact, imposition of it upon the defendant was problematic in this case. If there's no further questions, I'll yield the rest of my time. Thank you,
counsel. We appreciate the briefing and argument presented on this matter. We'll take the disposition of this under advisement and issue a written ruling in due course. With that, we're adjourned. Thank you.